Hello and welcome to this lecture on the law of agency. This is a very important topic also in law, in that in understanding this topic, then we are able to understand how parties to an agency relationship are able to conduct their affairs. So the key terms that we are going to be seeing in this particular topic are three, and these three terms are also the main parties in an agency relationship. So one of the main parties in an agency relationship is the principal, and we are noting that this is the person who also authorizes the agent to act on their behalf. So he or she, we can also say that, is the person who gives assignments to the agents to be able to act on their behalf. An example of this kind of a relationship is a relationship that we have with what we call property agents and the owners of the houses. So the owners of the houses could be residential, it could be commercial, are the principal in this context. And then the agents who act on their behalf collect their rents, ensure the property is clean, ensure every tenant is cooperating. That those kind of people are the agents. So in defining the agent, then we are saying that he is a person who acts on behalf of the principal, and they create a legal relationship with third parties. So the third party in this context, for example, in the example that I've just given, the third party in between the owners of a house and an agent, the third party is presumed to be the tenant, the person who has rented that particular space. Now, we have different kinds of agents, different classifications of agents. We have number one classification that is based on the extent of authority. And that one we have, for example, what we call the general agent. When we talk about a general agent, is somebody who has a broader authority to perform all acts that are related to a particular business or role. An example of a general agent, you are going to say, for example, is a branch manager. You are going to find a branch manager maybe for a bank, for a retail chain, is the overall person in that particular institution. He can be able to hire and fire. He can be able to make purchases. He can be able to act on behalf of the entire organization. And he represents the organization in various forums. So he doesn't have anything unique or a single thing that he's doing, but he's doing a variety of roles. So we call that person a general agent. Then we have what we call the special agent. This person is authorized to carry out specific tasks or transactions. For example, if you are selling your property, you can appoint somebody to help you execute the selling bit. And one thing about the special agents, once that act has been done, that becomes the end of that agency relationship because it was for a specific task. Then we have what we call universal agents. We are noting that these are limited authority to act on behalf of the principal on all matters legally permitted. So we invoke the aspect of law, that law has to permit a universal agency to act on behalf of the principal. And this law is granted with what we call the power of attorney. An official written document is prepared, and it gives the directives, for example, to an agent to manage the legal, financial, and personal matters. For an example, an elderly person who maybe not be able to understand how transactions are done. So an appointment can be done for that person to act on the elderly person on matters legal, financial, or personal. We move to another classification on what we call a classification as per the nature of work. The first one is a broker. This is a very, very common term. So ideally, a broker is the one that we know And we are noting that he acts as an intermediary to arrange buying and selling. I'm sure you've maybe encountered brokers in your day-to-day activities. But what do the brokers do? They will the pricing will be having an extra amount of money, and that is how they earn from that particular selling agreement. And that's why we are saying, and it is also important to note, even for the brokers that we have interacted with or we have come across, it is also important in the second statement that they do not possess these goods. So it is not their goods. And finally, out of helping the principal maybe sell an item, the broker earns what we call a brokerage commission. And then we have an example of brokers also in the selling of shares is what we call stock brokers. They just act as an intermediary for you to be able to buy and sell your shares. The second classification is the person we call a factor, an agent we call a factor. And you are noting that this person has possession of the goods and authority to sell in his own name. Now, what happens in the factor agency relationship between the principal? We are saying that he has possession of goods and authority to sell. But we need to remember that these goods still remain owned by the principal, but the factor is selling them as his own. For example, you can go to town and find a very big laptop shop, only that you don't know that the laptop shop owner has entered into an agreement with a manufacturer of laptops that I will manufacture, I will bring them, I'm not going to sell them to you. So you are going to sell as your own. And then at the end of that transaction, there is an amount they receive, and the other amount it goes back to the manufacturer. And he has rights. He can be able to give credit for these laptops. He can be able to receive payments. He can be able to make a pledge for goods. And we're also noting that a factor has a general lien. General lien means he has possession of the goods and also has insurable interest. So that is a very important type of agent under the nature of tasks. Then we have classification based on the nature of work, also a continuation. Another common kind of an agent under this classification is an auctioneer. They are appointed to sell goods by public auction. Remember, when you have taken credit or loans and, for example, you have defaulted, the financial institution will appoint an auctioneer to seize all that you own, and they sell them in what we call an auction. So an auction is just a public engagement where all your goods are displayed to the public at a particular location. And then we usually say that the highest bidder is the one who goes home with the goods. And we also usually say they go home with the goods at the fall of the hammer. When we are talking about the fall of the hammer is when the auctioneer rings a bell. This person always has a bell. So the bell is to announce that we are almost winding up the bid. Any other person who has a bigger amount, so whoever bids the highest for the property or for the item, they are able to take home the item. So the financial institution is going to use that method to try and recover the monies that you have not paid. Then we have what we call commission agents. They sell goods for commission and as possession of goods. You're going to find nowadays most companies also employ commission agents. That person is not designated any salary at the end of the month. The amount you earn is based on how much you're going to sell in terms of whatever products and services that are being offered. So we can call that a commission agent. As we come to close around the classification, we also have what we call a del credere agent. A del credere agent. We are noting that this kind of an agent sells goods and guarantees payment from the buyer. Now, the difference between all these other agents and del credere agents is that a del credere agent is going to guarantee the principle that you will be paid. So in the instances where the money is not paid, it is interesting to note that a del credere agent can be held liable. An example is an export agent, and his work is to guarantee that foreign buyers are going to pay for the goods that have been shipped. In the event they do not pay, the difference between a del credere agent and all these other agents is at the aspect of him guaranteeing payment. So if the payment is not done, then he is or she is held liable. And we are noting that a del credere agent is paid an extra commission called a del credere commission. Then we have other classifications still under that headline. We have bankers. We're noting that they normally act on a debtor-creditor relationship with customers. And bankers also come in agents in the case that once you deposit a check, if it is not a check for that particular bank, then they are going to ensure that you still receive your money. So they are going to link with the paying bank that you can be able to receive payment in your account. And then we also have forwarding agents. I'm sure you have heard about the term clearing and forwarding. When we talk about forwarding agents, especially you are going to find these around ports. And their key purpose is to be able to handle transport, to handle customs, to handle delivery of goods for exporters and importers. And finally, their knowledge is around shipping laws and matters around the port. Those are forwarding agents. So they are meant to make our work easier when we import, when we export around the port. They will advise on customs that you need to pay. They will advise on storage costs that you need to pay. They will advise on the best warehouse for you to keep your item if you're not picking it immediately, and so on and so forth. And finally, or last but not least, we have what we call non-commercial agents. And these kind of agents are not engaged in trade, but in professional or personal services. The best example that we can give there are lawyers. So lawyers are going to be acting on behalf of their clients, but on a professional point of view. So those are non-commercial agents. Now, a very important discussion on the creation of agency. When we talk about the creation of agency, we want to understand how does the relationship between a principal and an agent come into being, or how does it exist? Number one, when we talk about the types of contracts, for example, we talk about express contracts, implied contracts. So we are borrowing that particular information directly from the types of contracts to bring it here as number one and number two. So the first way that an agency relationship is created is by what we call an express agreement. And in contract, we say express means either orally or in writing. We are going to see those statements in our subsequent slides. Then we have implied agreement. And we usually note that when we talk about implied agreement, it's about the conduct of parties. If one person conducts themselves in a manner to suggest that they are an agent of a principal. Yeah, for example, where you live, you could be seeing somebody come every end of the month and try to find out whether you have paid your rent. Even if the landlord has not communicated to you that somebody is going to be coming, and they come the first month, the second month, the third month, throughout the year, that is presumed that it is implied by the conduct of them coming to your doorstep every month. it implies that there is an agency relationship. Then we have by necessity, we have by ratification, we have by operation of the law. So let us look at each one of them. So by express agreement, we are saying agency is created through written or oral agreements between the principal and the agent. And implied, inferred from the conduct or situation of the parties, just like I've just demonstrated or explained in that relationship of your agent, your house agent. And then we have what we call agency created out of what we call by necessity. And we note that it is created when someone acts on behalf of another in an emergency to be able to protect their goods. Now, the fourth one is what we call, before we move, you need also to check that under implied agreement or an implied agency, we have other versions of agency under implied, and we have three of them that you need also to check under implied agency. Number A under implied is what we call agency by estoppel. And what happens in agency by estoppel? We know that the principal actions may lead a third party to believe someone is an agent. So the principal may conduct themselves in a way that in the presence of a third party can ideally conclude this person seems to be an agent of the principal. So it is the principal's actions and conduct. Still under implied conduct and agreement, we have what we call agency by holding out. And this is, it means a repeated conduct by the principal. Regular conduct, a repeated conduct by the principal. And finally, under agency through implied agreement, we have what we call agency by cohabitation. I'm sure the term cohabitation is also not a new term to you. And it is an example of a cohabitation agency relationship is when a wife living with her husband, and it is presumed that the wife has authority to pledge his credit for necessities. Necessities could be food. And this means if the husband does not maybe forbid the wife on pledging credit or taking a loan, then he is presumed to be liable. The wife could maybe be going to the shop to take credit. So the shopkeeper would be having a right to ask the husband, your wife was here and she borrowed or she picked these a number of items and they have not been paid. The husband has a right to make that payment because it is presumed that they are living together. One can be able to act on behalf of the other. The only situation where the husband cannot pay is number one, unless he had forewarned the shopkeeper not to allow the wife to take credit. Or number two, if he had forbade or refused his wife to take credit. Number four, and a very important one, is what we call agency by ratification. Now, agency by ratification is an interesting one. And we note that it occurs when a person acts without authority, but the principal later approves the act. So what happens in agency by ratification? Number one, the agent is going to go forward and undertake a task or carry out a task without the authority of the principal. But later, once the act is completed, it is when now he goes back to the principal to approve the act. That's why we mean by the term to ratify, to agree. But this ratification, we are saying it is done after an act has already been committed. For example, somebody can maybe get a client for something that they want to sell. Other times that ratification comes in is in situations of emergency. Probably I realized that in your shamba, for example, the items that you planted were perishable. And if you are not aware of the situation, I can go ahead and sell the items. It could be tomatoes, and then later I can come back to you and explain to you, by the way, I sold your tomatoes, and then at that point, as the principal, you approve that that sale happened. You accept. Now, agency by ratification has what we call essentials of a valid ratification. How can the principal now agree on something that has already been done and it was not communicated in advance? Number one, for us to have a valid ratification, an act must be done on behalf of the principal. So, by the virtue of you selling those tomatoes, then you cannot be doing them for somebody who you are not going to go to request for them to ratify. Yeah? That's why we are noting that the agent must have acted intending to represent the principal. The second one, and very, very important, principal must have full knowledge of material facts. So you cannot go and force somebody to ratify what they do not know. So you have to sit them down, explain to them, maybe in the case of those tomatoes, as to why you felt you needed to sell them. Explain to them, maybe you noted they are almost becoming perishable. So if the principal does not receive full knowledge of what to ratify, then they cannot ratify, or the ratification will not be valid. So this particular point is emphasizing that the agent must disclose all the material facts. That's why we are noting here full disclosure of facts. And full disclosure of fact, even in the situation that I've just given around tomatoes, you need to tell the principal about the price, how much did you sell, what was the quantity, and the terms before approving the contract. This particular area on essentials of a valid ratification is an extremely important area that you need to note. It is an area that is extremely examinable. Another essential of a valid ratification, number C, principal must be in existence and competent. So you cannot seek ratification for somebody, for example, who has died. So the principal must be in existence. When we are talking about competency, they also need to be persons of sound mind. They also need to be persons who are not bankruptcy. They also need not to be minors. So that's why we are noting capable of contracting. Who are the people that are capable of contracting? They are the people that I've just mentioned. Another essential of a valid ratification is acts must be lawful and capable of ratification. So when you are going back to the agent or the principal to tell them, please ratify this act that I did, then the kind of acts we are noting down number D, they need to be legal acts. Legal acts are those that have been authorized by the laws of the land. And the other one is ratification must be in total or total. Now, this simply means that the principal then, in my example of tomatoes, cannot accept to ratify a certain number of kgs and fail to ratify a certain number of kgs. So, in short, we are saying if the principal has to ratify, if he has to accept the act, then he is going to accept the entire act and not just part of it. And then we are noting also ratification must be within a reasonable time. Yeah. It must be done before the third party withdraws or circumstances change. So you cannot do an act and then you are going to the principal maybe after 1 year. I did this act for you. Please rectify. Please accept. We need to do that within a reasonable time. And finally, on the creation of agency from our list here, this one that I had shown you here, The last bit is agency by operation of the law. And you are noting that these arises automatically in certain legal relationships. We usually have discussions around partnerships. And the example that we are giving here on agency by operation of the law is that a partner is an agent of the firm for business purposes under the partnership law. Now, what is the difference between an agent and a servant? We are noting down that on the side of an agent, they act on the behalf of the principal. We have noted that. A servant will always act under the employer's direction and control. On the second one, on the side of the agent, this person will have more independence in decision making. Remember, he has been given authority by the principal. On the side of the servant, they are going to work under close supervision and control, definitely of their employers. And then the third one is that a principal is liable for the wrongs of his agent done within the scope of his authority. Whereas on the other side, a master is liable for the wrongs of his servant if they are committed in the course of employment. So the employer is going to be held liable. On the side of agent number 4, an agent may work for several principals at the same time, and servants usually serve only one master. That's why when you go to many employment contracts or many employments, you are not allowed to be doing any other activity. The employer expects you to be loyal. But if you look at an agent, even for the property agents that we have just talked about, you're going to find somebody has created and made their name around property management, that they manage so many properties for different people. That's what we are saying about on the side of agents being able to act for several principles. And then finally, the agent has freedom to make decisions about how to carry their duties. The servant will always receive directions from the employer. A very important area also to discuss is what we call the rights and duties of an agent. So what are some of the duties of an agent? Number 1, the agent needs to follow instructions. And instructions are as per the principal's directions. Number B, the agent needs to act in good faith. This particular duty emphasizes on the need for an agent to be honest and loyal to the principal. The other one is use skill and care. So when you have been assigned this responsibility by the principal, then you need to carefully perform your tasks, and also with a lot of competence, so that nothing goes wrong under your watch as an agent. Number D, another duty is to be able to avoid conflict of interest. That simply means do not act against the principal's interest. And number E, it is important also to maintain accounts. That simply means as an agent, you have a duty to keep proper records and render accounts. Rendering accounts means anytime the principal needs to review transactions that you have entered into. For example, in the agent-tenant relationship, probably the agent can have a very good record in terms of how the tenants are paying their rent throughout the year. Then anytime the principal acts about that information, they can be able to receive the information. And then the agent also has a duty to communicate. And communication is emphasis on sharing relevant information with the principal when need be. And number G, no secret profit. So the agent cannot be able to enter into transactions to benefit him and make a secret profit. You have to declare everything that you are doing to the principal. And finally is the final duty of any agent is to be able to return property. And returning property means you hand over money or goods received on behalf of the principal. Even at the point of property managers, when they receive these monies as rent, it is not their money. At a particular point, as agreed with the principal, they are going to return or transfer the money to him or her. Then an agent also has rights, and these rights have to be respected. Number one is right to remuneration. So from the acts that they have done, they are supposed to be paid. We have seen different types of agents: commission agents, factor agents, brokers where you earn a brokerage commission. There is none of that relationship will be just there for free, but it doesn't have any consideration. So remuneration is very, very important. The other one is right to retain goods. So he or she can keep goods until paid. That is also very, very important. The other one is right to lien. So he holds goods for unpaid dues. When you are not unpaid, you have a right to hold the goods until the payment has been done. Right to be indemnified. When we are talking about indemnified or to be indemnified, the principal has a right to give you any amount that you have incurred in the course of your agency relationship. Maybe you have spent an extra cost. That's why we are noting all the losses and liabilities that have incurred lawfully. You can be indemnified. We can also use something like to be refunded any amount that you have spent extra. The other one is right to compensation in case you suffer any injuries within your activities. Some could be due to the principal's neglect. Probably, for example, you already indicated to the principal that the car that he has assigned for you maybe to do activities ABC requires service, and the principal has not acted. In case of any accident, and they had not acted in terms of undertaking the service, then you have a right to be compensated. And finally is a right to act in emergency. You can be able to take necessary steps to protect the principal interest. Sometimes in emergency is where now we bring ratification. Because it was an emergency, then you can act and then go back to the principal to be able to remind him and notify him of the act that you did. We also look at the duties of the principal. Number one is to be able to pay remuneration, so pay the agent in time, indemnify agent, that is about covering lawful expenses, compensate for injury, for any harm that has been caused, and not to prevent lawful acts. That simply means as a principal, you need to let the agent do authorized work. And finally, as the duties of the principal, you need to act in good favor. That means you need to be honest and fair with the agent. The rights, those are the duties of the principal. So what are the rights of the principal? Number one is to be able to recover damages due to loss occasioned by the agent's disregard of directions. If you give, as the principal, you give the agent certain directions and they do not follow those directions. So in case anything happens, an accident happens, then as a principal, you have a right to recover damages from your agent simply because they did not follow the directions that you gave them. The second one is resist agent's claim for indemnity against liability incurred by the agent out of negligence. Sometimes agents go out there and they are negligent, but they want to go back to the principal still to be indemnified, still to be compensated we are noting that the principal has a right to reject or resist such kind of claims. So this one is going to assist the agent to be very keen. Like you have seen duty of care, they need to be very keen and explore the highest level of competency so that they do not become negligent and hoping that they are going to be indemnified. Number C is right to demand accounts. So this involves inspecting all the agent's records and transactions. The other one is right to terminate. So dismiss agent in case of breach of a contract or breach of the agency relationship. The principal has a right to terminate that kind of a relationship. I have seen and heard about property agents that will always be lying to the principal that a certain house within the property has not been occupied, or a number of houses. So if the principal realizes that there has been that kind of an arrangement, then they can be able to terminate the agent's relationship because they have not given true information about the occupancy of the houses. And this is common in those houses where people collect cash, or even if it's being deposited in the bank. This agent could be telling the tenant, you give me your money in cash. In that sense, the money doesn't get to the principal. And finally is right to profits. Claim secret profits made by an agent. We have said as an agent also, it is your duty not to be able to make any secret profits. So if the principal realizes that there were secret profits made, they can be able to claim those profits. Now, we have two important concepts that we are going to be seeing next. Number one is what we call the doctrine of an unnamed principal. Now, we are noting that this doctrine is going to apply when an agent tells the third party that he is acting on behalf of the principal. Underline the final bit of that statement, but does not reveal the principal's name. So you can be acting with a third party, and you as the agent do not reveal the name of your principal. That is referred to as the doctrine of an unnamed principal. And we are saying still in this situation, the principal is still bound by the contract, even if he is unnamed. And we are also noting that the agent is not personally liable unless there is a trade custom that makes him liable. And finally, if the agent refuses to reveal the principal's identity, then the agent becomes personally liable. So it is good as an agent to be able to disclose that you are acting on behalf of the principal. The only situation that brings us here is that even though you have said you are acting on behalf of a certain principal, you have not named them by name. So that in agency relationship is called the doctrine of unnamed principal. Then we have another one we call the doctrine of undisclosed principal. So in this context, the agent hides both the principal's name and the fact that he is acting as an agent. So by doing so, you make the third party believe that he is the real contracting party. So you need to know the difference between unnamed principal and undisclosed principal. So we have said in undisclosed principal, you don't disclose anything. Number one, you don't disclose you are the you have a principal. Number two, you don't disclose that you are the agent yourself. So what do you think a third party is going to presume? The third party would presume that probably you are the principal because you have not disclosed any of that. So what are the liabilities of an undisclosed principal? What happens where an agent did not disclose he was acting on behalf of somebody? Number one, acts in his own name. The agent appears to act on their own behalf. So the subtopic, sorry, should be reading the liability of undisclosed principal. So Number A, the agent acts is in his own name. We have already noted that in the instances where you have not disclosed, automatically the third party is going to presume that you are the principal. So you are acting in your own name and you cannot hold anyone liable. Liability number 2 on the principal's liability, the undisclosed principal is still liable to the third party once discovered. You need to underline that, once discovered. If later that it is discovered there was a principal, you could be held liable. Probably the agent is failing to disclose because of personal interests. But at the point where it is discovered that there was a principal, then you will still be held liable. And we have what we call third party rights. And we are noting upon discovery, the third party can sue either the agent or the principal, but you cannot be able to sue both of them. We are going to look a case around Cook versus Wilson. That case is supposed to help us understand third party rights. To simply tell us, even if there is a discovery that there was a principal, remember the agent had not disclosed, you cannot sue both of them in that you want to recover huge amounts from both of them. You can only sue one of them for breach. So the case on Cook versus Wilson, 1856, helps us to understand our third point on third party rights. So what happened here? There was an agent called Wilson. He entered into a contract with Cook to purchase goods. And we're also noting that Wilson, the agent, did not disclose that he was acting on behalf of a principal. And then later, Cook discovered that there was an undisclosed principal. And he later also went ahead and sued both the agent and the principal. So the final is that the court held that Cook could not recover from both the agent and the principal for the same liability. So Cook could only sue the agent only, or either sue the undisclosed principal only, but you cannot go and sue both of them. It is presumed that you want to benefit more by each of them maybe paying you some damages, which will not be right. So personal liability of an agent. Number A is undisclosed principal if the agent hides the principal identity. So that is the first one. The other one is so when we are talking about personal liability of an agent, it is asking ourselves, so when will an agent be personally liable? Number one is in situations where he has not disclosed the principal. Number B is in situations where the principal was incompetent. Incompetency, we had mentioned it in one of our slides. It is either the principal was a minor, either the principal was bankrupt, either the principal was of unsound mind, then the agent will personally be liable. The other one is signing in his own name. If the agent signs the contract in his own name without stating he is acting as an agent, definitely he will be held liable. Number D is in the situations of a non-existent principal. If the principal, like a company, does not exist. You can imagine somebody indicating that they are an agent for a company that has not been incorporated. If it is realized, because issues around incorporation of companies, we have government documents that can show the exact date that that company was incorporated. So in that case, then if he purported to act on behalf of a company that was not incorporated, automatically he is going to bear what we call personal liability. And then the other one is exceeding authority. If the agent goes beyond his authority, he is liable for the unauthorized portion. Remember, we say the principal gives you directions of what to do. So if you go ahead and do more than that, then you will be held liable. We also have a very important discussion what we call delegation of authority. And we begin by noting down that an agent cannot delegate their authority to another without the principal's consent. And this in law is what is called delegatas non potest delegare. It simply means, that term simply means a delegate or an agent cannot delegate further. Or when we talk about a delegate, it is the person who has been delegated work, like the agent now. They cannot delegate further to a different person. However, we are noting that delegatas non potest delegare has exemptions. And exemptions is, when can a delegation be allowed in an agency relationship? Number A, it is a situation of custom or trade. If it's common in that trade to appoint sub-agents, we could be undertaking an act where around that area, you can be able to appoint agents. I've seen in the matatu industry, on the public service transport industry, you're going to find one public matatu or vehicle has more than 3 drivers in a day. Yeah. So that has been a custom around that area. I presume even the principals who are the owners of those cars could be having information around how these fellas operate. Excuse me. And also, other exemptions on when an agent can delegate is in relation to the nature of the work. The nature of work could be something difficult that they cannot be able to execute on their own. Number C is the principal's knowledge and no exemption. So if the principal knows that you have delegated and they have not given any objection, then delegation is allowed. And the other one is in emergency situations, when unforeseen emergencies make delegation necessary. The other one that delegation is allowed in an agency relationship is in ministerial acts, if the act is mechanical and not requiring skill or judgment. And finally is on the principal's permission, when the principal expressly allows it to happen. So you can be asked about the maxim or the term delegatas non potest delegare, and you're asked, give us exemptions as to when delegation is allowed, even though we are saying in the general rule that delegation is not allowed. Explain to us the exemptions or situations when we can be able to allow delegation in an agency relationship. As we wind up, we are going to be looking at the termination of an agency. How does an agency relationship come to an end? Number one is by act of parties, mutual agreement. So both the agent and the principal agree to end the relationship or the agency. The other one is revocation by the principal. That simply means the principal can cancel the agency relationship. Some situations before it has been exercised, or even when they realize that you have acted on issues around fraud, on issues around misrepresentation. Number C is what we call renunciation by an agent. And when we talk about renouncing, we mean that the agent may give up the agency voluntarily. You recuse yourself from the relationship. And then we also discuss about termination in another area by operation of the law. So operation of the law could be number A, if the business has been completed. It could be expiry of time. Probably you were to do the agency relationship for a period of time. Maybe it was a fixed time. Then that relationship comes to an end. Then death or insanity of either the principal of the agent, insolvency of the principal, and also sometimes insolvency of the agent. And also is destruction of the subject matter. If whatever you are dealing with is destroyed, you have seen buildings being brought down because they have not complied. If the agent that was acting on behalf of the principal in that kind of a relationship and the building has been brought down, then that is the destruction of the subject matter. There is no property again that is bringing us together for any relationship. And finally is the principal losing legal capacity. E.g., they are minors, they have been declared insane, they have been declared bankrupt. So as part of the reading assignment in this area, on your own, you're going to read about the extent of agent's authority, make some statements around that, and also read about what we call irrevocable agency. And that is going to bring us to the end of this session.